My name is Marci and I'm the Member Services Coordinator here at AFSA. Welcome to Minimizing Legal Exposure Upon Return to the Workplace, presented by Erik Eisenmann. This presentation is a part of AFSA's Business Partner Webinar Series, which allows industry experts to share timely educational topics directly with AFSA members. The webinars are designed to provide information that allow AFSA members to more effectively design, develop, and implement strategies for their company's success. For more information about how to become a presenter, feel free to reach out to me following today's webinar. A few housekeeping notes. To ask a question, use the question box on the side of your screen. I'll read them aloud to all following the presentation. The slides of recording of today's webinar will be available later today on AFSA's website in the Webinar Resource Center. Finally, you'll receive a survey after the webinar is over. Please take a moment to complete it. Your responses help us fine-tune the program so we can target the issues that are important to you. And now I'll pass it over to you, Chris.
Okay, and if you're still on, can you confirm that I have sound?
Yes, you're good.
Okay. So hello, everyone. Thanks for joining. We've got a full agenda, so I'm just going to do a brief introduction. For those that don't know me, my name is Chris Keiser. I'm the General Counsel at Flagship Credit Acceptance, brought to you from my basement in Westchester, Pennsylvania. I have the privilege of being the chair of the Emerging Issues Subcommittee of AFSA's Law Committee, and two outside lawyers are counsel to the subcommittee. If you don't know them, they're Marci Kawski, who is a partner at Husch Blackwell, and Kelly Lipinski, who's a partner at McGlinchey Stafford. The three of us meet every couple months to come up with issues that we present to the full law committee, and normally not outside of the law committee. As you might suspect from the name of the Emerging Issues Subcommittee, the purpose is to discuss issues that are emerging in the legal environment. Generally, they're new and novel legal issues rather than issues that we all deal with day to day in our businesses. So with everything happening with COVID-19, Kelly, Marci, and I met and agreed there's lots of novel issues, and this would be a ripe one for discussion, and how to manage legal risk as we manage returning to our workforces and getting back in business. We know there's a lot of webinars being presented by different law firms and consulting firms. Our intent with this one is to be a little bit different. The situation is evolving day by day. So for example, if you go back 2 months, the CDC was not recommending the use of face masks, and of course they are now. There's been changing guidance on how long the virus stays active on surfaces. And a month or so ago, we weren't hearing very often about people who were refusing to wear face masks or to observe social distancing. So those are a few examples of how things are evolving. In light of the fact that things are changing, rather than give specific guidance to you, what we wanted to do is give you a playbook for, not to give you a playbook for how to enter the workforce, but instead to arm you with an understanding of the law and emerging trends in the law so that you could issue spot and then seek counsel as appropriate as things come up. Since most of these legal theories arise from employment and labor laws, Marci, Kelly, and I are not experts in that area. We decided to invite Marci's partner, Erik Eisenmann, to present. Erik is a partner at Husch Blackwell, based in Milwaukee, and he's also the chair of Husch Blackwell's labor and employment practice. Erik, we thank you very much for putting in some hard work in a short period of time to present to this group. And without further ado, I will turn it over to you.
Thanks, Chris. Thanks very much to the members of the committee for inviting me to present and for working with me to put together today's presentation. As Chris mentioned, what we're hoping to do today is to give all of you on the call here a little bit more specific background of the various different legal theories that we could be facing as employees are returning to work. Chris mentioned that he was coming to you live from his basement. I've been spending a lot of time there as well. I am actually in my office, but I'm the only one here today on the 18th floor of our office here in Milwaukee, Wisconsin. I think many of you are probably in the same space as I am, which is starting to think about coming back. And if you're part of this group, you're thinking and worrying about the same things that I am, which is, what are the different potential areas of liability that your businesses might face. So what I hope to do today, again, is to give a good framework to help you understand some of the legal elements of those claims, Also welcome comments that you might submit during the presentation today. So please feel free to submit those electronically, and I'll try to remember to stop and ask at various points during our presentation today if you have something specific that I've mentioned that you'd like more info on, or something else that's on your mind. As I mentioned, as employees are returning to the workforce, we believe it's inevitable that there are going to be legal claims that are arising. We have already seen a rise in litigation in the employment context in some areas, some of which we're going to touch on today, and those include claims regarding failure to pay, retaliation, and wrongful termination. An example of those retaliation claims is something that I was working on earlier this afternoon, just before I got on today's webinar. A retaliation claim in relation to an employee who was attempting to exercise his rights under the new expanded family leave pay under the Families First Coronavirus Response Act. So these are things that if you haven't seen already, you are going to expect to see in the coming days and weeks. In addition to some of the things that I've outlined here, we really expect the scope of these claims to expand. And so one of the things I hope to do is be able to help you understand about what are the different kinds of claims that employees might bring. I'm going to start with, frankly, the one that I think is the most common issue that we can expect to see as employees are returning to the workforce, and that is workers' compensation claims. So there have been already a notable rise in workers' comp claims since COVID-19 was declared a pandemic. But there is an important threshold issue, and that is whether employees who file workers' comp claims are going to be entitled to compensation. Generally speaking, as you might know, workers' compensation does not cover routinely community spread illnesses like cold or the flu, because there isn't that nexus between the illness and the workplace exposure. Outside of the COVID-19 context, there have been some states that have made exceptions for certain workers who develop chronic illnesses like cancer that are a result of sort of repeated exposure. But this is a novel concept, this concept of an illness like COVID-19 being deemed a compensable injury under the workers' comp framework. This is, even for essential workers, there's going to be some question about sort of whether COVID-19 exposure becomes a compensable workers' comp injury. So let's talk about the elements of a workers' comp claim. I've alluded to those already. Ultimately, in order to prove that a workplace or an illness is related to the workplace, which would make it compensable, an employee would need to demonstrate that she or he sustained an accident or contracted an occupational disease, that the illness in this case both arose out of and occurred during the course of employment. And most statutes include this specific language which requires the employee to be able to point to an identifiable time and place of infection. And then finally, that last element is that there is a causal relationship between the accident and the resulting injury. So that there was this illness, that the illness arose out of the course of employment, and that there is this causal relationship. And it's that last element, that causal relationship, which is really the one that's going to be most hotly disputed in this context. What we've seen, and as you may know, workers' compensation is generally a framework of state law. So various states have taken different approaches on this. Many states have created a rebuttable presumption that a COVID-19 case is work-related for employees who are in high-risk fields, like healthcare workers or first responders. So a state like where I'm sitting, for instance, in Wisconsin, we had the legislature pass a law that says if an individual contracts COVID-19 and they're in one of those categories, there's going to be a presumption that it was work-related and that it would be a compensable injury. Conversely, there are some states that have expanded that even further. The governor in California recently signed an executive order providing that rebuttable presumption that an employee who is working outside of the home, and if they're diagnosed with COVID-19 within 14 days of performing on-site labor, that they would have a rebuttable presumption that that employee contracted the virus at work. So what that means is ultimately, rather than an employee having to prove all of those three elements that we've got here at the top of the slide, instead the employee is going to be able to start from the perspective that the illness is work-related, that it is a compensable injury, and instead the burden is going to then shift to the employer to be able to demonstrate that it is not covered. I've got some elements listed there at the bottom of the slide. Washington is one of those states that's taken the opposite approach, or kind of like the Wisconsin example I just gave you. Washington has created a presumption in favor of coverage for first responders or healthcare workers, but they've chosen not to create that presumption like California has. And instead, they've established these 3 criteria for evaluating COVID-19 claims. They ask, was there an increased risk or greater likelihood of contracting the condition due to the occupation? That's going to be the case if someone's a first responder or healthcare worker. Probably not going to be the case if they're a white collar worker. You know, most of my work as I'm coming back to work is going to be in an office context. Am I more likely to catch COVID here in an office space, particularly if my employer's enforcing social distancing, than I am if I'm going to the grocery store or attending an outdoor gathering? Probably not. Another element that they're looking at is, if not for the job, would the worker have been exposed to the virus or contracted to the condition? Again, what sort of outside activities would that individual have been engaged in? Finally, can the worker identify a specific source or event during the performance of his or her employment that resulted in exposure to the new coronavirus? So examples include the first responder or healthcare worker who has actually treated a patient with the virus. Another example that we could think of in not in the healthcare context would be an employee who might be working in one of these meat processing facilities. If they could be able to point to, yes, I was exposed to a coworker who worked next to me for an extended period of time without personal protective equipment or other steps, that'd be the sort of thing the employee could demonstrate. So here's the elements, from your perspective as the employer, what can you do to mitigate the risk that you would have an employee who would be able to argue that their COVID-19 exposure is related to their workplace exposure? Taking the common sense guidance that's articulated by the CDC, by the Occupational Safety and Health Administration, and we'll talk about that in a bit. Enforcing social distancing, choosing to require masks or face coverings. These are all things that an employer could do to, if we look at these elements, strengthen their argument that there was no causal relationship between the accident and the resulting injury. Here's an example, right? Employee contracts COVID-19. They argue that it came as a result of their exposure from work and that it's a compensable workplace injury. If we do not have any other reported cases of COVID-19 at the workplace, or if we had a reported case, but we immediately took appropriate steps to quarantine that individual, to undergo cleaning, and there's no evidence that there was any other transmission, that's going to be a strong defense against one of these workers' comp claims. So this is what I think is going to be one of the more common claims that are brought. As I said, you should check what your state law says about this burden of proof and this presumption. But the strongest way to defend against one of these claims is going to be taking the sort of precautions that we'll talk about in a little bit from the CDC, from OSHA, other steps like that. That's a good segue to my next section, which is an investigation under the Occupational and Safety and Health Administration. OSHA has seen an influx of complaints alleging that employers have not done enough to protect employees. OSHA is the primary body that investigates and addresses alleged workplace issues. And so, it makes sense that OSHA would be, an entity that's receiving a lot of these complaints. What is relevant for us to know as we talk about our framework here today is that there is no specific OSHA standard on point related to COVID-19. There is not a specific set of guidelines that an employer that's subject to OSHA has to follow or do in order to satisfy its duty to keep the workplace safe for employees. There are a number of outside entities and individuals who are arguing that OSHA should enact a standard like this. So there's a pending lawsuit that was filed by the AFL-CIO against OSHA, arguing that OSHA should issue a temporary standard that gives guidance specifically to employers. There was legislation that was passed in the Federal House of Representatives on May 15th, directing OSHA to develop an infectious disease standard. That bill was not passed in the Senate, and it's unlikely that would happen. So again, that's not binding guidance. And in fact, just several days ago, the acting OSHA administrator explained that there is no forthcoming standard that will specifically address COVID-19. So, as we sort of set the basic building blocks here, there is no specific requirement that OSHA has regarding what an employer needs to do to ensure there's a safe workplace in the context of the pandemic. That said, there still are OSHA-related obligations that an employer has to follow when it comes to COVID-19. And that's because in addition to the specific standards that OSHA statute has, there is also a general duty clause, sort of a catch-all clause in the OSHA standard or the OSHA guidelines that requires employers to furnish, quote, employment and a place of employment free from recognized hazards that are likely to cause death or serious physical harms. And so what we have historically seen is that OSHA may seek to enforce this general duty clause, this general standard, against employers that they believe are violating general health and safety guidelines, even if there isn't a specific OSHA standard on point. So what this means is if an employee is going to OSHA and complaining that his or her employer is not providing a safe workplace, it's going to be under this general duty clause that they're bringing that claim. What's difficult for employers is that, again, there's not a clearly articulable standard. That's one of the things I think you'll be asking yourself as we go through this whole presentation. I wish there was more black and white rules that I could know exactly what I needed to do, and we're just unfortunately so early in this pandemic process that there aren't as many of those. So that's the frustrating part. The good part about this general duty standard analysis is that it's a fairly high burden for OSHA to be able to demonstrate that an employer has failed to provide a workplace free from recognized hazards. So if an employer can take steps, as I mentioned before, regarding environmental controls in terms of restructuring the workplace, cleaning, communicating to employees' expectations, doing other things like temperature taking, and these are all things that we can talk a bit more about later in the presentation, that will be a strong defense against this kind of OSHA claim. I include here some discussion of PPE, personal protective equipment, because this idea of face masks or coverings is one that clearly is top of mind and becoming a real hot button discussion point. There's language here that comes out of the OSHA standard, and it requires an employer to provide PPE, quote, wherever it is necessary by reason of hazards of environment encountered in a manner capable of causing injury or impairment through absorption, inhalation, or physical contact. The question is whether the COVID-19 pandemic creates that environment where hazards are present such that an employer is required to provide PPE. And what I can tell you is that OSHA has not issued a standard that says that an employer is required to issue PPE as a function of doing business. I think what that means is if an employer is operating in a particular business where there is a higher risk, first responders, meat processing facilities, I think there OSHA would probably try to rely on this standard and the general duty standard that we looked at the prior slide to take the position that an employer does have that duty to provide face masks or coverings. And that's a good segue into this next bullet point. What is the difference between face masks or coverings? And actually, we just got a question that came in. If OSHA doesn't issue a standard, can we still be found culpable? So I talked in that last slide about how there's all these various bodies that want OSHA to issue a standard. And I've said that it does not appear that that's going to be forthcoming. Can we still be culpable? Yes. OSHA still can issue a citation and seek penalties based on this general duty standard that I described. If they find that an employer has not taken sufficient steps, and they aren't giving us a lot of definition about what those sufficient steps are, they could try to bring that citation against us. And again, when we talk about masks or face coverings in the PPE context, if you're in the first responding industry, if you're in meat processing, that's very different than what our audience today here is in. So, I think let's take a step back. And I wanted to mention this concept of masks or face coverings. Sometimes you're hearing those terms used interchangeably. They actually have different legal significance. From the perspective of OSHA, a mask is a medical grade protector, like those N95 masks that you're seeing or you're reading about, that filters, 90+% of particulates from the user. A face covering is what you and I have been wearing as we're going to the grocery store or out and about. That's something that can be made of cloth. An employer has a special duty if they're going to be requiring employees to wear those N95 masks, to do training, to potentially do what OSHA calls fit testing to make sure that they're being worn correctly, possibly to enforce rules regarding facial hair so that those masks would fit properly. Those same rules do not apply to face coverings. Face coverings, the more informal ones that I mentioned, you know, an employer does not have a special duty to jump through those extra steps. And one of the big questions that you're getting, that I'm getting, is, you know, what is an employer's ability or obligation to require those? If we go back to this point I just made about sort of providing a safe workplace, there is not a de facto rule that requires an employer to provide face coverings. In some states, you will see state rules and regulations requiring those, or requiring employers to provide those in certain settings. Some of those states have rules that say if you're going to require face coverings, that the employer has a duty to provide them. And at the end of the day, we are still in a framework where that decision about whether to require those is up to the discretion of the employer. I think we are seeing a critical mass, more and more businesses that are choosing to do that, both from an OSHA perspective, also potentially from an employee relations or a client or customer service perspective. As I alluded to before, what are some of the concerns here as we talk about OSHA? Why do we care about this? You know, an employee complaint can lead to an on-site investigation that can result in fines or other regulatory action. I've got a bullet point here that talks about the OSHA 300 recording obligation. There was some question about whether, if you've got a COVID-related issue in the workplace, is that a work-related injury or illness that you would have to typically record on your OSHA 300 log? OSHA's done a flip-flop on that. Back in April, OSHA issued some guidance suggesting that for most businesses, unless there was a clear evidence that the exposure was work-related, the employer did not have to record that exposure on its OSHA 300 log, that log of illnesses and injuries that virtually all employers are required to maintain. OSHA then sort of reversed that in the last week in May, and it's now creating a presumption in most instances that if you have a COVID exposure, you as an employer do need to record that. I have a question coming in here. It mentions, you know, OSHA also requires a licensed respiratory administrator and policies and procedures if you require masks. That's exactly right. I was going back and talking about, you know, this concept. If you're using these N95 masks, you're going to have to jump through a bunch of hoops, including these respiratory administrator identification and these policies that the question makes references. It makes it cost prohibitive for some companies. How do you reconcile? It's a good question. The good news, I would say, is that in most instances, we have not, you know, even in those industries where, you know, OSHA might say that an employer has an obligation to provide some sort of face coverings, we've not yet seen OSHA guidance which suggests that they're required to provide masks, you know, medical grade masks, but instead it's the face covering issue. I think the exception would probably be in some of those first responder settings where the N95s would be required. It would be, and it could be cost prohibitive for a small business. That concept of the cost of an abatement step like that is one that is directly central to sort of the analysis that OSHA does. So it is possible for an employer to say, listen, doing so is simply not feasible for my business. But ultimately, it's going to be a pretty high standard for the employer to make. It's going to have to show that it really would create a severe financial hardship and that there are other ways that you could control that exposure. We got another question on this issue that came in. What is the likelihood of OSHA investigating an office or a call center environment? That's one that, you know, folks here on the call, you know, probably are going to be experiencing. And what are they doing differently given the number of complaints that they are receiving? I think the likelihood of OSHA investigating an office space or a call center space is fairly low, in part because they are focusing the limited resources and time that they have right now on those hot spots that we've read about. So it's the extended care nursing facilities, the food processing plants, the places where there have been these outbreaks. Now, that's probably now that more accurate now that we're sort of in this triage mode. Is it possible that as things start to evolve, there will be more OSHA enforcement activity in sort of the white collar office setting call center space? I think that's entirely possible. And I think it's very likely that there will probably be some of that enforcement activity in at least some office type spaces across the country. There was an article in the New York Times about a week ago about how there are all these quote unquote hazards for employees who are returning even to offices. Things in offices like water in the pipes that haven't been used and possible exposure to Legionnaire's disease. So I would say, regardless of our industry, even in an office context, if we're dealing with places where employees are in close proximity and having to sit in those spaces for extended period of times and to be talking, right, which is something that could potentially create pathogens, there is a risk. And if there is an employee complaint, there's the potential that you could have that follow-up OSHA inspection. I'm going to segue here now to the concept of negligence. So we've covered workers' compensation, we've covered OSHA claims. Now negligence, which is a concept that those of us who have legal experience and background are generally familiar with from our law school class in torts. This is probably, when we hear people talking about claims against businesses, this is really the sort of thing that I think that a lot of people are talking about. But you'll see as we dig into this a little bit, that when we think about this in the context of the employment relationship, it's actually going to be very rare that these are going to be successful claims. So we've seen some of these negligence claims already, alleging that an employer acted negligently by failing to implement proper precautions or failure to follow CDC recommendations, which then led to an employee contracting the virus. So that's the way that this claim gets framed. And the elements to this sort of negligence claim are the ones that you, again, would recall from torts class, that the employer had a duty to the employee, in this case, a duty to protect the employee from COVID-19, that the employer breached that duty by failing to maintain proper precautions, right? And then there's a causal connection between the breach and the employee contracting the virus. If you contrast this with the workers' compensation analysis, there are actually two hurdles here for someone who's trying to prove this claim, right? Okay, let's say they can prove a duty. They have to show first that there's that nexus, that causal connection, that the exposure to COVID-19 actually happened in the workplace. But they also have to show that there was a breach of a duty. And this goes back to some of those takeaways that we were talking about. If we as an employer are developing policies, taking steps, benchmarking what we're doing against others in our industry, that's going to go a long way to demonstrate that we are satisfying whatever duty we might owe. So that's the general background on the negligence claim, but the most important takeaway on these potential negligence arguments is that if an employee is going to be trying to make one of these claims, they are going to have to overcome the threshold issue of the workers' compensation exclusivity doctrine. Some of you may be familiar with that is, but the idea is in most jurisdictions, an employee has only one avenue to bring a claim against her employer, and that is that she can file a workers' compensation claim. The bargain that society has essentially struck is they said, we are going to make it fairly easy for an employee to recover benefits for an injury that they suffered at work. We're not going to really require that much of them to show that the employer acted wrongly, but instead simply that they suffered this injury. And the trade-off to that is that it's going to be workers' compensation liability, which is capped. That there's a statutory maximum to the amount of benefits that a person could receive then, or medical expenses, which, most or all of you are going to have insurance that's going to cover those sort of claims. So, an employee may want to get out from under that because they say, no, I want to bring a negligence claim so that I can recover additional damages. There are a handful of exceptions to this workers' compensation exclusivity doctrine. The first that I don't have here is that in some states, Texas being an example, an employee has the right to choose whether to file a workers' compensation claim, which allows them to more easily recover benefits, but caps those benefits at that statutory amount, or to proceed under a negligence theory. You're not able to double dip, but in a jurisdiction where you're allowed to the employee can choose that, there's some risk, and this negligence analysis is something that we would have to take a look at. The other exception, which is going to apply in virtually all jurisdictions, even those jurisdictions that don't have this dual track, but instead have this single workers' comp avenue for employees to recover, is this concept of intentional conduct of the employer. So even in a state where an employee is generally limited to a workers' compensation recovery, there's typically going to be language in the statute or in case law. It says if the employer or its agent engages in some sort of intentional conduct, that an employee might still be able to bring a negligence claim. So the early COVID-19 lawsuits that we've seen against employers are focused on this concept, trying to argue that there's this intentional conduct of the employer. And they claim that the employer failed to close locations despite knowing that other employees were displaying these COVID-19 symptoms, that the employers failed to prevent employees with COVID-19 from coming to work, that the employers hired new employees without screening them for COVID-19 symptoms, that they failed to adequately clean or sterilize workspaces, or that they failed to adequately promote social distancing. So I'll say two things about that paragraph that I've got there. The first is that even if these facts are as they are alleged, it strikes me that many of these are actually alleging negligence rather than intentional conduct. You know, failing to close locations, not enforcing social distancing. Does that satisfy a standard of an employer who's intentionally exposing an employee? I think those employees who are bringing these claims are going to have a difficult time meeting that intentionality standard. But even if they do, this sort of paragraph and these claims are creating more of a roadmap for you to assess, you know, what I can do as an employer to prevent one of these claims from ending up on my desk. You know, promoting social distancing, which means making sure that we're taking steps to change the workplace if we need to, changing our policies that allow that social distancing to occur. We talked about the office or call centers context, right? If we have a call center, if we haven't already, we probably want to take steps that will allow employees to sit at least 6 feet away from each other. Maybe that requires us changing the actual configuration of the office space. Maybe it requires us to go through some sort of rotating staffing process where employees are on one day and off the other, so we're only using 50% or less of our capacity. But those are the sort of things that you could do that then you would be able to respond to a claim like this and say, that's not true. Actually, when we had an exposure, we took immediate prompt action and we cleaned and sterilized the workspace. We did things in the workspace to ensure social distancing or prevent exposure. You know, when we brought new individuals into the workplace, we conducted and did screening. So those are examples of things that that an employer could do to sort of push back on this inference that we acted negligently. I'm going to open it up for questions in just a second, but the last thing I want to do on this negligence concept is mention that you will be reading and hearing about this legislation, right? Federal legislation that is being considered to limit employer liability. When you hear people talking about that, I think this is what they're getting at. You know, additional legal action that would create exposure, or rather prevent exposure for employers, to give them an extra level of protection against these kinds of claims. And my editorial thought here is, my predictive thought is that I think it's going to be difficult for that legislation to pass because you have two strong interests on either side. The one way that this might happen is I think you could foresee some sort of liability protection in this context for employers as a result of a trade-off for interests that those on the other side might have. But this concept is you know, limiting liability for employers. This is where we're getting into that. It's something that's being discussed, but it's not clear that that's something that ultimately is going to get passed. We had a question that came in that said, okay, we've been talking about this negligence concept. How do we prove a lack of intent or negligence? Well, the first thing I would say is that ultimately negligence or intent is going to be a burden that the plaintiff effectively has to prove. So the plaintiff is going to have to prove negligence or prove that intent. Ultimately, to rebut that or to defeat that showing, you know, we're going to essentially have to show that no, we acted reasonably, or even if we didn't act reasonably, we didn't act intentionally. So we weren't aware of those risks. In sort of the example that we've got here in the paragraph, you know, if the employee alleges that we failed to close locations despite knowing that other employees displayed symptoms, you know, did the facts actually show that we knew employees were displaying symptoms? Was that information that came up to decision makers, or it was simply something that employees were discussing amongst themselves? I think that's an example of how we would try to defeat an argument that we were acting intentionally. So as I close this negligence section, I wonder if if this might be a good time for us to open it to other questions that we've got. I know folks have been submitting those along the way, but I'll break just a second here to let anyone share those if you've got questions about what we've covered so far. Okay, didn't see any come in the wire here, so I will proceed. The next category I was going to talk about here are whistleblower or retaliation claims. These are cases or claims that could be brought by an individual who believes that they were terminated or that their employer took some sort of adverse employment action against them as a result of the employee raising a concern about COVID-19 or exercising their rights under some of these various different laws. So there are two legal elements to this claim. The first, that the employee brought a legitimate complaint or concern regarding safety or rights. And second, that the employee was terminated or there was some sort of adverse employment action as a result of that. The first element is what we sometimes refer to as protected activity, engaging in protected activity. And the second is this one that's going to sound familiar to you now, but that there's some nexus or causal connection between that protected activity and the action that the employer took. So one of the examples that we've seen of one of these retaliation claims is a case that was brought in Kentucky State Court against Trader Joe's. This was a case that was brought under Kentucky's common law public policy wrongful discharge statute. So I'll frame that for you and mention again, a lot of these claims are going to be dependent on what the state law actually is, which can vary from jurisdiction to jurisdiction. You might expect, Kentucky's law is not going to be quite as employee friendly on this in a state like New York or California. So I think jurisdiction is pretty important to us here. In this King versus Trader Joe's case, our fact pattern here is ultimately that you had an employee who's alleging that Trader Joe's refused to allow him to wear gloves while he was working, that they refused to allow him to self-quarantine when he had been exposed to somebody with COVID-19 but had not yet didn't contract it himself. They required him to come to work. He alleges that they failed to take appropriate safety or cleaning steps. And then finally, a fact that I think is interesting here and one worth noting for our group is that he actually created a Facebook page where he aired some of these grievances and encouraged other employees from his location to comment or join the group. Ultimately, he's terminated. The employer alleges the termination was a result of other performance issues that he has, but he claims that he was terminated because he engaged in this protected activity. So, this is still at the complaint stage. There has been no recovery in this case or no finding that Trader Joe's actually engaged in this activity. But we're talking about it here on this call. You can read about it in the newspaper. This is precisely the sort of PR issue that you all want to avoid. So it can be a helpful example for us, I think, of some of the, the risks that we want to avoid. In all of these, there's going to be two sides to the story. But an employee who's raising these, what he or she believes to be legitimate safety complaints, we as the employer simply want to be able to demonstrate that we are taking those claims seriously. We certainly don't have to, respond in the way that an employee always is asking for or to, enact wholesale changes in every instance. But at least in this complaint, the allegation is the employer basically blew this guy off when he was raising these concerns. And then finally, this Facebook page thing I think is interesting. We want to make sure that we aren't simply reflexively terminating somebody or taking action against them for a violation of our conduct policy if they create a Facebook page or are engaging in some sort of commentary on social media. Because if that's, concerted activity, and we'll talk at the end of the presentation a little bit about an employee rights under the National Labor Relations Act, there's a chance that that can simply be perceived as retaliation for someone who's raising a legitimate safety complaint. There are, in addition to the state law claim that I mentioned, there are causes of action that protect whistleblowers under a number of these different statutes that we've talked about today. The Occupational Safety and Health Act, claims under the ADA, the Families First Coronavirus Response Act. Actually, this morning just got a new case involving an employee, as I mentioned before, who is bringing a claim under that cause of action. And finally, the National Labor Relations Act. So we looked at these elements. I wanted to give you some recommendations and best practices to avoid this kind of claim, right? Never terminate an employee simply because he or she complained. If you're going to terminate somebody who has a history of complaints, be sure that you have a really good reason to do so, and probably talk with your outside counsel before you take that step, or your in-house counsel who's familiar with the way that this works. Reviewing, publicizing, and enforcing reporting procedure for employees who express concerns regarding COVID-19. If you've got a policy like this in place, it makes it much more difficult for somebody to say, well, no, they were just ignoring me when I raised this, or I didn't know who I was supposed to go to address this concern. Potentially being more flexible in this context of allowing telework. Some employees might be raising a request to continue to work remotely. You don't have an obligation to grant that in all instances, but to consider that is probably a good way to protect yourself against some sort of retaliation claim. Make sure that you've got policies in place that address anti-retaliation, whistleblowing, and reporting. This is an important one. Reminding supervisors and training or retraining supervisors and managers. Often in an organization, you could have a very well thought out plan, clear policies, invested a lot of time and effort in making sure that you got the right pieces in place to respond to these issues. But if we're not communicating those down the decision tree, if the frontline people who are dealing with these issues when they come up are not aware of and understanding what their obligations and duties are, then all that time is for naught. So we want to make sure that a supervisor should be taking those concerns seriously, even if the supervisor perceives it as frivolous. We don't want the supervisors or the person who's receiving that to be in the position of having to assess those things. That is not their job. Their job is to receive that information and refer it to somebody else, whether it be HR or whoever else you might designate. But we don't want those individuals to have to be the person making those decisions. I've mentioned the National Labor Relations Act. This is the federal law. People think of it as the law that primarily addresses organized labor unions. But you may know that the NLRA actually addresses virtually all private employers. It applies not simply to those entities that have a union in place, but almost all private employers are subject to the law. And so what we've seen is these under the NLRA, walkouts, sickouts, employees raising collective concerns about exposure to COVID-19. And if employees are doing this, if they're acting in a collective way, that activity may be considered protected concerted activity under the National Labor Relations Act. And if we as the employer are taking aggressive action, like terminating employees who are raising those concerns, we could be on the receiving end of an unfair labor practice and find ourselves before the National Labor Relations Board, even if we don't have a union in place. I got a couple questions that come out here, and I think these might be on the previous slide. One of them was asking for providing more detail on the good elements of a reporting procedure. I think key elements of a good reporting procedure would be that it is very clear about, one, the method in which an employee can make a complaint. Two, that it probably has multiple methods by which that complaint can be reported, right? So we don't want the only avenue that a complaint can be made to go up directly through an individual supervisor. But we want to make clear that you can refer it to your supervisor. If you're not comfortable doing that, you could bring it directly to HR. Or in some bigger, more sophisticated organizations, you might actually have a third party or a hotline that receives those complaints. So I think having a clearly communicated procedure in place is pretty important, making sure that it includes those multiple different avenues of communication. And then the final one is to create a clear process internally that makes clear what we do with that complaint once it gets referred. Step one is going to be for us to issue some sort of confirmation to the person who made that complaint. I'm confirming that I've received this. We're going to take and we're going to deal with it according to our policy. And then make sure that you are following your policy, whatever that may be. As I alluded to before, we don't have to, undergo a detailed investigation and inquisition every time we receive a complaint, but we do have to follow some process or policy. And so making sure that we aren't ignoring things, I think, is the last sort of comment that I'll make on that. We've got another a question here that says we have salespeople out visiting car dealers. They are working in environments we don't control. what liability can we have if the dealers aren't observing safe practices? And how do we reduce this legal risk? Great question. We may be liable as an employer, even if an individual worker is in an environment that we don't control. Let's look at this through a couple different lenses. First, in the lens of, in the context of a workers' compensation claim. If our employee contracts COVID-19 while they're performing services for us, even if they're not in our workplace, that is likely, almost certainly going to be a compensable injury. Now, if they contracted it while they were grabbing a burger and a beer at the bar before or after they visited the dealership, now there's a potential defense. But in most instances, we're going to have that issue. Beyond the workers' compensation issue, we looked at the concept of negligence or intentional conduct. The way that we can protect ourselves in that context, I think, is, doing our own due diligence to ensure that we're not putting employees into situations where there is an unreasonable risk, providing face coverings for employees to wear when they're taking those steps, providing hand sanitizer for them to use in that context, and then to bring it back to the reporting procedure, to probably clearly communicate to those employees that if and when they feel that they are in any kind of unsafe procedure, to create a mechanism whereby they can let us know that. And again, that's not going to be a get out of jail free card where somebody can say, well, I don't feel comfortable going anywhere, so I don't have to do my job anymore. But I think if we put a communication in place that shows, all right, if you've got a concern, this is who you bring it to, and then we address that in those instances, I think that's going to go a long way to protecting us and limiting our legal risk. Another question that came in was a question about temperature taking and what the legal aspects are of taking temperatures. We had looked at this earlier in the presentation when we were talking about some of those pre-screening. There's a little bit of context here. Historically, taking an employee's temperature or taking the temperature of a third party potentially who came in, like an independent contractor, would be considered a medical examination, and that we would generally be prohibited from doing that under the Americans with Disabilities Act. That would be a prohibited medical examination unless we had a specific business necessity to do so. So a default policy of requiring temperature taking would be against the law. At the initiation of the COVID-19 outbreak back in April, the EEOC issued new guidance and said, in light of the pandemic, an employer policy requiring temperature taking for all individuals or all employees who are entering the workplace is acceptable and is not a violation of the ADA, as long as we're not collecting that information along with names and maintaining that in a place where it could be disclosed. And we're doing it in a way in which we're keeping employees safe. So many employers began doing that, particularly I think in some manufacturing settings, was doing temperature scans. What my own law firm is doing is we're returning to work is I have a log that I'm being asked to take my own temperature and to write that down on a daily basis, and to stay home if I have a temperature above 100 or certain other reporting obligations like that. So the short version is you are allowed to do the temperature taking. Again, to the extent that I can make an editorial comment, there is mixed data about whether that temperature alone is an accurate predictor of illness, and evidence that suggests that some folks without temperatures could be spreading the virus. So I think this temperature issue, there's an element of employee safety in it, and there's frankly also an element of PR in it, which is that it can be a way for some employers or some businesses to demonstrate that they're taking steps and layering different steps to do what they can to protect employees. There's a question that came in about HIPAA. I think there might be a common misconception here. An employer is generally not subject to HIPAA. A employer is not going to be a protected entity that is subject to HIPAA in the same way that a medical provider is. So you have all sorts of obligations to keep your employees' information confidential that flow from typically common law and statutory confidentiality requirements, but you are going to generally not be a HIPAA-covered entity. So HIPAA isn't going to be violated, but it's these more common law confidentiality concerns that I think you want to be careful about. Do we have to provide thermometers if we say you're going to take your own temp before coming in? I can tell you that my law firm is not doing that. The question would be, Does the law require that? Let's see, for non-exempt employees, for hourly employees, I do not believe that there is any case law that would suggest that an employer is required to do that. However, I would say for an employer who's going to implement that sort of rule, doing that probably makes sense if you want to ensure compliance. I'm going to segue back to the NLRA here and bring us to the conclusion of the presentation. I wanted to just flag this concept of employees who might be engaging in this group activity. It can potentially create this liability for you under the National Labor Relations Act. There are some cases here that I've cited that talk about special protections basically for employees when they're engaged in collective action to protest what they believe to be unsafe or unhealthy working conditions. So I think we can expect to see more of this. Again, this is going to be much more common, I think, in the manufacturing or food processing industries. But Amazon, for instance, is one that's been in the news here. They had a group who was engaging in these concerns. Some of those individuals were terminated. As a result, there's been an unfair labor practice charge that's been filed against them. We have a question came here that I think is good. What if we have employees refusing to follow our policies, like wearing masks and staying apart and following social distancing? Can we be liable for that? Good question. This goes back to sort of, I think, one of the OSHA concepts, and that, if you catch an OSHA citation, and they said, for instance, that you weren't following safety procedures, one of the defenses that you as an employer can raise is you can say, listen, we had a policy in place that required employees to wear hard hats, for instance, and we did training to make sure that employees did that. And the way that that defense is successful is for you to demonstrate, yes, I had a policy, and then what that means then is it's best if you have that in writing. While it's not technically required, it's going to be much more helpful for you to be able to point to that policy or that procedure in writing. And then second, what sort of evidence do you have that you consistently enforce that? So what our question is what happens if we've got these people who aren't following our rules, who aren't wearing masks? If we are consistently enforcing our discipline and saying, listen, if we catch you without a mask, we're sending you home. Or if we catch you not enforcing social discipline, we're sending you home. And if you do it a second time, we're going to suspend you, or taking some steps like that. That's, I think, going to be sufficient for us. And then even if in another situation, someone argues, well, I saw so-and-so wasn't wearing the mask, and I believe that's where I was exposed, and so I think the employer acted negligently and has liability. Our ability to say, listen, we had the policy, we trained on it, we consistently enforced it, that's going to be an extraordinarily strong defense against a claim like that. I've got a section here on the Fair Labor Standards Act. This is the federal law that addresses wage and hour. I want to hit a couple of the highlights here. Places where we see litigation risks for employers. Tracking hours and overtime for remote or non-exempt employees. So we're in a way different world right now than we were 3 or 4 months ago when we talked about remote work. And many businesses now have employees who would typically be doing work in the office, now doing that exact same work from home. What sort of policy do you have to ensure that your hourly non-exempt employees are not performing work off the clock? Because if they are, even if it's contrary to our policy, even if it's not approved, we have an obligation to pay that time, okay? So if an employee is consistently working off the clock, that's time for which we have an obligation to compensate them for. So you as an employer, you can say you're not allowed to work more than your 40 hours. And if we find out that you do so, we can take disciplinary action against you. But we're not allowed to say that we aren't going to pay that time. FLSA considerations and salary reductions or conversion from salary to hourly. I have this in here because as a result of the pandemic, business considerations, I think, have caused a lot of us to have to make changes. In some instances, it's layoffs or cuts or salary cuts for salaried employees. But some businesses have actually converted salaried or exempt employees to hourly or non-exempt employees. And doing that carries its own risks under the FLSA. Obviously, you have to start tracking time, paying overtime, and there's a potential impact on others that are performing those same jobs. So I wanted to flag that here. I've got some discussion here about some layoffs or lawsuits that we've already seen regarding deficient COBRA notices. That's going to be really boring and put you to sleep. So suffice to say, make sure that you consult with, your benefits provider or your outside benefits counsel when we're issuing those notices, because there have been more of these that have been issued as a result of the layoffs and furloughs that have occurred, and already a bunch of litigation for employees saying notice did not comply with the specific requirements in COBRA or ERISA. There's a good question here that I want to touch on that just came in. What do you do with those employees who say they have a religious or medical reason not to wear a mask? How do you protect those that say they don't want to be on site with those that refuse to wear them? Let's take that in two parts. The first is somebody that has a bona fide religious reason or a bona fide medical reason not to wear the mask is generally someone that we're going to have a duty to accommodate. So somebody that's got asthma and can't breathe with the mask on, or somebody that actually belongs to a religion that prohibits them from utilizing a face covering. We probably would have to accommodate those individuals. Now, that doesn't mean that we would allow them to necessarily work in the middle of other employees. We could accommodate them in another way. We just said, okay, you don't have to wear the mask, but we're going to put you in another area of the facility where you're not having close contact with another individual. What I've seen is individuals who simply don't want to wear the mask for political reasons, or because they don't like the way that it feels, or they think that it interferes with their ability to do their job. Those are people that do not fall in one of these protected classes. So they in general did not have the right to refuse to do that, and you can enforce that rule against them. How do we protect those who say they don't want to be on site with those who refuse to wear them? I guess the question here would be, if you've got a policy that consistently requires employees to wear them, but there's a handful of individuals who have these sort of medical accommodations. Again, if we are moving those folks who aren't wearing the masks to areas where we are limiting their exposure, I think that we are probably well within our rights to require an individual to come back and work. And someone who simply has a concern or anxiety about coming back to work is not generally going to fall in any of these protected classes. There's a question that came in here which was touching on this prior slide, and I want to hit this very briefly. If our employees have to wait in line for temperature tests or elevators, do we have to pay them? So you see here on the slide, the CDC has recommended and the EEOC has authorized employers to take temperatures and screen employees for symptoms. So we talked about this before. We have the right to do it. The Department of Labor, which administers these wage and hour laws, has not weighed in on whether that should be compensable time, whether we have to pay employees for that time. And there's this whole analysis of whether this is a principal activity, if it's a substantial or significant period of time. And there's regulatory guidance on this, and most courts that have analyzed this have basically said that if we're talking about something that's less than 10 minutes, that's de minimis and that it's not going to be compensable. How long is it going to take for an employee to wait in line and get these tests, or to wait for the elevator? So the answer to the question of whether this sort of stuff is compensable time for our non-exempt employees is we don't know. If we want to be conservative, we treat it as compensable time, that we pay employees for that time that we're waiting. I fully recognize, however, that as we're talking about a larger and larger group of employees that are doing this, those minutes are going to add up and going to be pretty substantial. I anticipate in the next 45 or 90 days, we're either going to see Department of Labor guidance on this or litigation that starts getting filed that's going to give us some clarity. My gut is the courts are going to argue that most of these sort of screening things are de minimis, that they fall outside the scope, and that an employer does not have a duty to pay it. But we don't have that guidance to hang our hat on. So I say that as a prediction, not as legal advice. And I would say, if we're going to be conservative and we want to make sure that we're not creating risk, it would be to pay that until we've got guidance to the contrary. The last section that I've got here today is third-party claims. Again, all of the things that we've talked about up to this point have been claims that would be brought by employees against a business. This last section is, potential claims by a customer or a third party who comes in. And we could do a whole separate hour on this. But again, I want to just highlight a couple points here, right? These are going to be based on the same theory of negligence, about whether a business operated reasonably and took appropriate steps. The downside of these is they could expose the business to these greater theory of liability. And we've seen one example of this are the lawsuits that have already been filed against the cruise companies. So it's a class action lawsuit against the Grand Princess cruise ship, and those are claims that are seeking emotional distress, and punitive damages. We've seen some public nuisance claims. There was a public nuisance lawsuit that was filed against Smithfield Foods, which is a food processor in the Midwest, alleging that they didn't take steps, so their employees got sick, and those employees spread that in the community. That was ultimately unsuccessful. It was dismissed early on in the life of that lawsuit. But again, a risk that employers need to think. So my takeaway, I guess, on these third-party claims is we should think about them or analyze them in the same way as we looked at those negligence claims from employees, which is, how can we say, what can we demonstrate to show that we've acted reasonably, that we have not breached whatever duty we might owe? And that's going to come down, I think, to us relying on the guidance that we have, whether it be the CDC guidance, whether it be OSHA guidance. Chris mentioned at the top that that's tough because it can be a moving target. No masks before, now we're talking about masks. But it's staying apprised of what the law is and showing that we're investing time, that we have policies on point. If we are acting in good faith, I think it's going to be difficult for either an employee or a third party to bring this kind of claim. So I think I am at time. I guess I'll defer to Chris or Marci or others if there's anything else that we need to discuss or any sort of parting comments that we want to make.
Thank you, Erik. We have a few questions. Can we require antibody tests? What if someone refuses? Might we be negligent if we don't test people or make them test themselves?
This concept of requiring antibody tests, again, is a little bit of a gray area, but the guidance that we have suggests that the EEOC authorization to do these temperature screenings, allow medical exams, probably extends to antibody tests as well. Antibody tests are going to be a little bit more invasive, but we have the right to conduct some sort of blood drug testing in some instances. So I think the concept is that we may be able to require that. If somebody refuses, again, if they don't have a medical reason or a religious reason to do so, we probably have the right to decline to bring them on. Could we be negligent if we don't test people or make sure that they test themselves? I think that goes back to sort of the analysis we did before. And so what I would say is that, if we are in a community where there's a high rate of spread, if we are in an industry or where there are lots of people getting sick, and if we've had experience of a number of cases in our own workplace, I think implementing a testing procedure like that probably would be a requirement to defend against a claim of negligence. If we're operating in a place where we haven't had cases or the rate is fairly low, or we've taken other steps to address the risk of transmission, I think that we could make a strong argument that we're acting reasonably even if we aren't requiring those tests. So I'm sure that's kind of a wishy-washy legal argument, but I hope it gives a little bit of insight there.
Thank you, Erik. Another question is, once a vaccine is available, can a company require vaccination?
That's a great question. The short version is typically yes, depending on the industry. Again, I think there's going to be an analysis about whether there's a legitimate need to do so. Given that that we've the EEOC has already relaxed some of its rules for a pandemic, my prediction is that it would be permissible for an employer to require that, with the caveat, this exception that we talked about before, which is for people who have a medical reason or a religious objection. I think we could anticipate that religious objection thing could get to be a little bit stickier fight with vaccines than it is about face coverings or some of these other things. So tentatively, yes, but stay tuned for more details.
Thank you. Another question is, what are you advising clients on enforcing those mask rules against customers?
I would say that if we want to benchmark, the majority of my clients are requiring employees to wear face coverings when they are in non-private areas, so common spaces where they are exposed to others, whether it be customers or coworkers. Most of my clients are requiring employees to do that. I would say that it is a minority of businesses that I am advising that are requiring face coverings for all consumers or customers. Instead, what I'm seeing more common is that businesses are requesting or recommending that customers use those. I think a business has a right to require that, but I think it's probably some political and business considerations that is resulting in some of these businesses saying, well, we don't want to alienate any part of our customer base and make that a requirement, but instead make it a request.
Thank you. Another question is, what if we have employees that refuse to follow our safe environment guidelines? Can you term employment for someone who ignores on-site guidelines?
Typically, yes. Again, if you know, before you would pull the trigger and make that final termination decision, I think we'd want to make sure that we are thinking about the reason for the objection. Again, making sure that it's not a medical reason or a religious objection. But if it's, again, somebody who's just being reckless or careless or doesn't like those rules in general, they're not going to be in any special category, and we could take that kind of action.
Great, thank you. And if you want to ask a question, there's a question box on the side of your screen. We'll give another minute or so.
Okay, I think that's it. Well, it's been a real pleasure talking to the group today. Thanks for taking some time and working through this. I understand that it's a moving target, but you know, it's a satisfying part of my job to be able to work with clients and help work through these issues. So I appreciate you giving me the opportunity today. Chris, do you have anything to say as we wrap up?
No, thank you very much for putting in the time. I think it was very informative, and we thank you and virtually applaud you. So thanks, Eric, and thanks everyone.
Thank you so much. Remember, the slides and recording will be available on AFTA's website. Thank you so much. Stay safe, everyone.